Hi, I'm Victor Strauss. I practice law in St. Louis and have done so for over 30 years. Generally, my practice involves injury law and civil litigation. The three questions that I probably get the most from clients are, in an automobile collision, if the other party causing damages has no insurance, is there a claim? Which generally means, are there collectible damages? Yes, provided you have liability insurance on your auto or the auto you were riding in. You automatically have an uninsured motorist claim for bodily injuries. This is because liability coverage generally includes uninsured motorist, which is required by state law. This will cover your damages for medical expenses, lost wages, lost earnings, lost future earnings, and other damages such as pain, loss of use, or loss of mobility. Also, if you're covered by medical payments coverage on the auto you're driving or perhaps under your own policy, your medical bills will be paid as well. The second question that comes up is the insurance company for the party causing the injury will tell you that you had back problems before, or your age means that you had arthritis or some condition and you weren't in tip-top shape anyway. By law, you're not required to be in perfect shape to make a claim for damages. The law is practical and allows for recovery when a previous condition is aggravated or intensified. Another thing I run into is oftentimes a company will say that a previous condition that had no real symptoms or caused any problems is one that prevents recovery or minimizes recovery. If you did have arthritis before, and most people have it after they're 25 to a degree, but there was no pain, and now you have pain, obviously that's something that should go in your favor in a claim for damages. So that's something that needs to be submitted. The third situation I run into is where people walking in the snow or ice or on a slippery surface suffer a mishap, and the insurance company for the defendant or the responsible party will say, well, it was open and obvious and you knew of the condition and you encountered it anyway. Generally, the law will allow you to recover and submit a claim for damages because if you're reasonable in traversing the area or surface, there's a good case that the defendant breached or violated a duty of care to keep the premises safe under the circumstances. You can't be denied a recovery just because you chose to walk after snow or ice fell or even the day after. Premises liability cases can be tricky, and it's probably best to consult a lawyer, particularly if you're seriously injured. In all these situations I'm discussing, it's best to call and consult a lawyer. If someone would like to contact me, my email is victorstrausslaw@outlook.com, and my website is Victor Strauss Law. My telephone number is 314-457-9673.